Welcome to this session. My name is James Russell. I head up the outsourcing and technology practice at Norton Fulbright in London. And I'm joined here today by Rohan Isaacs, who's a member of the team. And we're going to talk about two topics. The first is how to carve out willful misconduct from a limitation of liability cap. And the second topic we're going to talk about is whether an exclusion or limitation of liability clause applies to a deliberate breach. And we're going to talk about those two topics in the context of an outsourcing or a transitional services arrangement, where these issues often come up in negotiations. Now, to kick things off, I'm going to say a little bit more about what I mean by carving out willful misconduct from a liability cap. It's common in the realm of outsourcings and TSAs for customers to insist that willful misconduct should not be covered by a supplier's liability cap, meaning that if the supplier is liable under the contract, it should be liable to the customer for any losses it suffers on an uncapped basis. However, it's not entirely straightforward as to whether uncapped liability is always justified in the case where the supplier deliberately or recklessly breaches the contract. And I'll give you an example. Imagine you have a contract between a customer and a supplier of IT services in which the supplier assumes uncapped liability for willful misconduct. In this example, a junior member of the supplier's operations team deliberately fails to apply a security patch to the customer systems in breach of contract. And it may do so because there's a resource shortage or because the supplier has deliberately prioritized other customers ahead of the customer in question. But either way, the customer systems are compromised by the failure to apply the patch, and it suffers loss as a result. Now, in that case, the customer is clearly going to argue that the operation team's deliberate decision not to apply the patch amounts to willful misconduct. But in contrast, the supplier will be arguing that the deliberate actions of a junior member of its operations team, even though that ended up breaching contract, is not the same thing as the supplier itself deliberately or recklessly breaching the contract. But either way, in accepting uncapped liability for willful misconduct, it's opened itself up to a potentially significant legal battle.
As you say, James, I mean, we do see these things coming up quite often in contractual negotiations, but what's your view as to how high the bar actually is with what constitutes willful misconduct?
Well, this is the problem, that a lot of suppliers end up accepting uncapped liability in the belief that the bar is very high and that they'll never be engaged in inappropriate conduct that would come anywhere close to amounting to willful misconduct. But as we can see from the example, it's not always clear where that bar sits. And the problem is exacerbated by the fact that under English law, there is no fixed meaning for willful misconduct or willful default.
So what you're really saying is that it varies contract to contract.
Exactly, yeah. I mean, the determination of whether an act amounts to willful misconduct depends on a whole number of different factors, like the contract, the particular drafting of the clause and the facts in question. I mean, Rohan, you've been looking at the case law in this area. Perhaps you could give us a brief overview of what's going on.
Yes, sure. I mean, a few cases. The first one I'll mention is De Beers versus Atos Origin. And there the court really looked at what constitutes willful misconduct. And the court really said that if you are knowingly breaching a duty or you're being reckless about it, you're in willful misconduct. And this was more or less echoed in the case of high-tech projects versus MW Energy, where what the court really said is that if you are knowingly, deliberately breaching your contract or you're acting with reckless indifference to your obligations under the contract, you're in willful misconduct. And the last case I'll mention is quite an interesting one. It was the case of Innovate Pharmaceuticals versus University of Portsmouth. And very, very briefly, what happened is that the university did some research for Innovate. They published their findings in a journal. It then turned out that the findings were all wrong. The article had to be withdrawn, and Innovate said that the research was all wasted. And the reason for this is it turned out that the head researcher had acted in willful misconduct with regard to his duties. So Innovate decided to sue the university, and they wanted to sue for a higher amount than the limitation of liability under the contract. The limitation clause limited liability to a certain amount, howsoever arising. Those are the words that the contract used. And Innovate tried to argue that the university couldn't exclude or limit its liability for this willful misconduct. In fact, the court actually found that the words howsoever arising are in fact wide enough to limit liability, and they found in favor of the university. The court said a number of things. I mean, one of the interesting things the court said is that it's more likely to find favor with a clause like that, where a party is trying to protect themselves from their exposure to the potentially willful misconduct type activity of an employee or an agent, rather than their own personal willful misconduct. But James, what's your view on the implications that cases like this have for drafting of contracts?
I mean, it's a good question. I mean, I think it's clear from that final case that if the parties intend to exclude willful misconduct from a liability cap, then they must say so expressly in the contract. And given that the determination of whether an act meets the threshold for willful misconduct is a matter of interpretation, you often see parties agreeing to define what willful misconduct means when carving it out of the liability caps. Now, while that can lead to greater certainty under the contract, it can also present an opportunity for one party, which is typically the customer, most likely to benefit from the other party, typically the supplier, having uncapped liability if its actions meets the threshold for willful misconduct. And that's because the party can use the definition to lower the bar for willful misconduct below that set by the courts in order to recover maximum damages. So turning to the next topic, which we're going to talk about, which is whether an exclusion or limitation of liability clause applies to a deliberate breach. Rohan, you've been looking at some case law in this area. Perhaps you could give us a snapshot of what's going on.
Yeah. The law's actually evolving in this area. So there are a couple of interesting cases. I think in the old days, there appeared to be a rebuttable presumption against excluding liability or limiting liability for willful misconduct. That seems to be changing now. One can look at, in addition to the Innovate Pharmaceuticals case I mentioned, one can look at a case like AstraZeneca versus Albemarle. There's also a case of Pinewood Asia versus Pinewood Technologies. And in those cases, what the courts have really said is, look, there's no rebuttable presumption. You need to look at the construction of the language of the contracts. And in Pinewood in particular, what the court said is that it's not going to strain the language of the contract unnecessarily to essentially try and shoehorn it into some rebuttable presumption interpretation of the law. It's probably worth saying, though, that the Pinewood case is actually under appeal at the moment. So the decision could change. As I say, the law is evolving.
Clarity in contract drafting, from what you've just said, is absolutely crucial. And my key takeaway from those cases is that you can never underestimate the importance of clear and precise language in contract drafting. Yes. And if the parties intend for deliberate breaches to be treated differently in terms of liability to other breaches, then they must say so expressly in the contract. Otherwise, you risk a deliberate breach being treated in the same way as any other breach when it comes to liability caps and exclusions of liability in the contract.